Welcome. I am Austin Yenne, a member of the Palm Beach Young Democrats and lead contributor to the group's blog. This is the second in our recent series of recorded interviews. Continuing on our series of interviews, my latest guest is Yenne Millhiser. He is a senior fellow at the Center for American Progress. Mr. Millhiser is also the justice editor at the online site ThinkProgress and author of the book Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. Yenne was kind enough to take time out of his busy schedule to talk to me about the importance of the Supreme Court among a variety of other pertinent topics surrounding the court. I hope you enjoy. Thank you. What got you interested in studying law?
Oh, that's a big question. I was a school teacher in the Mississippi Delta, where you still had de facto segregation, and I saw that a lot of my students weren't getting, the same opportunities that they should have because they're poor. And I realized that wasn't a problem I was going to be able to solve, at least in a systemic way, as a classroom teacher. So I went to law school, intending to work as a civil rights lawyer to try to rectify some of those problems. Now, unfortunately, midway through my legal education, Justice Alito was confirmed, and I decided that I didn't particularly want to spend my career losing cases for a living. But my initial thought was that, the nation was not living up to many of its promises, and I could use the law as a vehicle to fix that.
To follow, do you have a law degree?
No, I have a JD from Duke. Juris Doctors, yeah.
Okay, so after you got your Juris Doctors, what did you do following that?
I did several things. I clerked for a federal judge. I worked for a few legal nonprofits, and then ThinkProgress originally brought me on to cover the Sotomayor confirmation. And since then, I've sort of bounced back and forth between being a journalist covering the court and occasionally doing some advocacy work. I organized a lot of the amicus strategy seeking to save the Affordable Care Act the first time it was before the Supreme Court. So I've been hovering in or around the Supreme Court for most of my career, and unfortunately, I think it's become an institution that is very threatening to progressive values.
Why was the Supreme Court created then?
Well, you need to have a judiciary. Congress can pass laws, but someone has to apply the laws to individual cases, and that means that there has to be often a lawsuit or a prosecution or something so you can determine whether the law applies to someone and what should happen because of it. And then you need a Supreme Court because you want the law to be, or at least you want federal law to be the same in Alabama as it is in Michigan, as it is in California, as it is in Virginia. And that won't happen unless you have one central body sort of overseeing the way that courts are deciding cases. The problem that we're now seeing with our system is that we don't do much of anything to insulate our courts from politics. Judges are chosen by an elected official and must be confirmed by elected officials in the Senate. That led to the gamesmanship you saw with Republicans refusing to confirm anyone Obama nominated because they wanted to ensure that they could get that seat for themselves. That means that presidents have every incentive to pick nominees who are going to put ideology ahead of, whatever legal principles are enshrined in the law itself. And, I fear that we are spiraling back to, for most of the Supreme Court's history, it was a pretty political and pretty ideological institution, and we're rapidly spiraling back to that because we don't have adequate safeguards to insulate our judges from just becoming very political.
To follow up on that, what would be some safeguards we could enact to prevent stuff like that?
Well, so one thing that you've seen is Missouri pioneered this, so it's often called the Missouri system. A lot of states will pick their judges using a system where they create a commission where various different constituencies are represented. So, the governor will typically have some appointees, but not a majority. The state bar will have some appointees to this committee. Various other constituencies to make sure that the Chief Justice will often either chair it or will pick someone to chair it. So you can set up a commission that won't completely eliminate politics, but at least minimizes it because so many different groups have input into what's going on. And then what happens in the Missouri system is, say, if a vacancy arises on their state Supreme Court, the commission will come up with 3 people who are selected entirely based on merit, and the governor will pick from amongst those 3. And in many states, that's proven to just be a much more effective way of getting judges who will do the work of a judge, which is a job that, as the name suggests, requires a degree of judgment, but who are going to evaluate cases through a legal lens and not necessarily as much through an ideological lens.
So you're talking about the Supreme Court enacting laws, basically, to make sure they're constitutional. So can Congress overrule the Supreme Court's decision? So, like, for example, the Supreme Court ruled in favor for Citizens United and broke open campaign finance laws that were restrictions. So, and now Congress is talking about overruling the Supreme Court. Wouldn't that defeat the purpose of the Supreme Court?
So the answer to that is it depends on what type of decision it is. The Supreme Court generally has the last word on matters of constitutional law, although conceivably Congress could propose a constitutional amendment. But most of the cases that come through the Supreme Court are statutory. So, for example, last week the court handed down a 5-4 decision that meant that companies could first force workers to sign away a lot of their rights to sue the company if the company breaks the law, and then the company could not only say, like, hey, you got to sign this thing, but they could say, hey, and if you don't sign away your rights, you're fired. Or in one case, we actually have a company that said, not only if you don't sign away your rights are you fired, we're also not going to give you the bonus that you've already earned by working here for all of this year. So you're seeing companies do some really disgusting stuff. They're able to do it because the Supreme Court has twisted the meaning of a law called the Federal Arbitration Act to cause it to do much more to protect companies that want to immunize themselves from the law than the law, like, on its face, actually says is allowed. Congress could fix that tomorrow. I mean, Congress could just pass a law saying this was wrong, employment contracts aren't subject to the Federal Arbitration Act. That would fix that problem. So there's a lot that Congress can do. The very first law that President Obama signed was the Lilly Ledbetter Fair Pay Act, which fixed an erroneous decision the Supreme Court handed down that made it easier for employers to engage in pay discrimination along gender lines. So Congress can do a lot here. You have to have a Congress that wants to do something about these problems, though.
So you were talking about not holding the company accountable, but wouldn't technically the decision they ruled, wasn't that more about instead of class action suits, they would have to go through arbitration?
Okay, so what the decision held is it held that your boss can say to you, you've got to do 2 things. One, you've got to give up your right to sue in a real court, and you have to go to a privatized arbitration system, and there's all kinds of data showing that workers are much less likely to prevail in arbitration, and then when they do prevail, they tend to collect a lot less money from their employer than if they had litigated in a real court. The second thing is it says that they can force you to sign away your right to bring a class action. And as a practical matter, if you don't have a right to bring a class action, a lot of your rights just don't exist. And the reason for that is, let's say that your boss steals $1,000. You do however much work you need to do that you have earned $1,000, and your boss just refuses to pay. You're almost certainly not going to sue over $1,000. And the reason you're not going to sue over $1,000 is because the cost of hiring a lawyer and actually litigating that case is going to be much, much more than $1,000. You're going to spend more to get that money back than you stand to gain. What class actions allow is that typically when a boss is engaged in that kind of wage theft, they aren't just doing it to one person, they're doing it pretty across the board. And it allows you to join together with all of your coworkers who experience a similar injury. Suddenly you've got a big, high-dollar lawsuit. You'll be able to get a really great lawyer who will work on a contingency fee basis so that you only have to pay a percentage of what you win to the lawyer. And suddenly this is a really viable case. So if you eliminate things like class actions, you're not just saying, hey, like instead of going to this form, you have to go to this form. You're effectively telling many workers that their lawsuits, their legal rights cannot be pursued anymore because the cost of vindicating their right is going to massively exceed the amount that they stand to gain if they win.
So one of the biggest cases we've had in the past decade that pretty much rolled back some of the civil rights was the Shelby County versus Eric Holder, which was based on the Voting Rights Act. The court obviously, as we know, ruled against Holder and ruled two provisions of Voting Rights Act unconstitutional. These provisions have been in place for over 40 years. Why all of a sudden were they just ruled unconstitutional?
Because John Roberts is an incredibly naive man, because he doesn't understand some very basic things about race and racism. What the Voting Rights Act did before parts of it were struck down by Shelby County is it said that certain states and certain localities that have a history of racial voter discrimination, when they pass a new voting law, before that law can take effect, it has to be, it's called pre-clearance. It had to be screened either by a judge or by officials at the Justice Department to make sure that this law wouldn't lead to racial discrimination. And laws like that are unusual. It is unusual for Congress to pass a law saying to a state, your law doesn't get to go into effect until someone else has had a chance to look at it. But there was a serious problem of racial, I don't have to recount the history of Jim Crow. This was a serious problem. The Voting Rights Act was extraordinarily effective in fixing this problem. In the 2 years after the Voting Rights Act became law, black voter registration in the state of Mississippi went from 7% to 60%. So this is a hugely effective law. There's nothing in the Constitution saying it's unconstitutional. And what the Chief Justice said in his opinion is he said, look, this is an unusual way of doing things, and that made sense when we had a lot of racism. But now we just don't have that much racism left in our country, and so it doesn't justify this unusual law. It's an interesting judicial opinion to read, which was, I think, completely discredited by the fact that 3 years later, Donald Trump became president. So you have a Chief Justice, and 4 colleagues on the court, who I think are at best willfully blind to the presence of racism in this country, and it leads them to say some rather foolish things.
To kind of follow up on this, the common belief, if you ask the average person that's obviously not on Twitter and not necessarily follow politics so much, is that they would assume that the Supreme Court is very nonpartisan, as we've been talking about earlier in this interview. Yet our justices are labeled conservative and liberal. How is the law broken down to where there's a liberal interpretation and a conservative interpretation? Wouldn't it just be pretty straightforward as it is?
Well, a lot of questions are hard. The Supreme Court is making some cases that don't need to be very hard. I don't think the Voting Rights Act case is a particularly hard case. I think they should have upheld the damn law. But, there are cases where our Constitution is very vague. It refers to things like due process and reasonable searches and seizures and the privileges or immunities of citizenship. These terms aren't really defined, and so no matter how good your judges are and no matter how nonpartisan they are, the job of being a judge is going to involve some amount of values judgments. The problem that you have with this Supreme Court is that, often they just seem to be making stuff up, as they did in the voting rights case. And B, there was a recognition in the early 20th century after the Supreme Court went completely off the rails, started striking down minimum wage laws and maximum hour laws and child labor laws and all sorts of basic protections for workers, that there needed to be constraints on the judiciary's ability to act. And the judiciary should generally defer to elected lawmakers because elected lawmakers actually have a mandate from the people and judges don't. And this Supreme Court seems to have abandoned that sensibility. So now we have a court that not only is reading the law in ways that I think are out of bounds or not within the realm of ordinary discretion, but it is also finding ways to exercise judicial power in areas where there's long been an understanding that the courts don't belong. Things like our health care policy should be determined by our elected officials, and not by whether 5 members of the Supreme Court like Obamacare.
So you talked about how we elect our officials. Should we rearrange the Supreme Court to where the people elect the judges?
I don't think judicial elections are a good idea, but there are ways to select judges through merit selection commissions. You know, a lot of European nations have professionalized judiciaries where, people, start off as a junior judge, and as they do well, they move up in the system and promoted by their fellow colleagues within the judiciary. So there are other ways to have a judiciary that fosters the same degree of independence without leading to the level of politicization that we have in the United States.
A lot of things I hear from conservatives is with judicial ruling is they talk about original intent of the law. Could you explain exactly what they mean by original intent versus what the law means today? Because wouldn't that mean that the law is flexible on its meaning?
Well, so here's the thing. Like, the Constitution, except for there are just a lot of vague passages in it. Again, it says police can't engage in unreasonable searches and seizures without defining the word unreasonable. It says that people should be given the due process of law without defining that term. It says that you can't have cruel and unusual punishment. It says that the privileges or immunities of citizenship must be respected by the states. And a lot of these very vague provisions, you can go back and try to find out what the original meaning is, and what you find is that there isn't a singular original meaning. You find out that, Thomas Jefferson and Alexander Hamilton spent the entire Washington administration bickering over 2 entirely different ways of reading this constitutional provision. So, I think that when people speak about originalism, they're often engaged in a shell game, because where the Constitution is clear, nearly everyone agrees how the Constitution should be read, and the Supreme Court, I think, has done, for the most part, a pretty good job of reading the clear parts of the Constitution in the way that any normal person would read them. The reason why judges, it matters who's on the bench, is because so much of the Constitution lacks clarity, and sometimes originalism is helpful in resolving those hard questions, but most of the time it frankly isn't. It just doesn't answer the question. And so I think when people, especially when I hear modern-day conservatives advocating for originalism, they're not actually saying, like, oh, there's this certain meaning that existed 200 years ago, and we just need to bring that back, because there wasn't a certain clear meaning that existed 200 years ago. What they're really saying is, I don't like current law. I want it to be overruled and replaced with something that aligns more with my values. And I'm able to find some historic documents which, if you read them in isolation, seem to suggest that maybe my preferred outcome is the one that the framers agreed with. So I'm going to wave these historical documents around as an excuse to get the result that I want anyway. But they're not really engaged in a serious historic inquiry. It's just advocacy by other means. It's advocacy by citing historic documents instead of by citing, precedents or canons of construction or any of the other methods that lawyers use in order to suss out legal meaning.
So, obviously, you were talking about the game that conservatives played in the Senate by rejecting Obama's last Supreme Court pick. Obviously, so once Donald Trump got elected, Neil Gorsuch was elected to the bench. You've talked at great length about how Neil Gorsuch concerns you, and other liberals I see are very concerned about Neil Gorsuch's ideology per se, while conservatives are praising him. What exactly about Gorsuch concerns you most?
I mean, he's a bad judge. He is simultaneously very smug and very certain that he is right, while at the same time handing down interpretations that are just transparently wrong. Literally, in the middle of his confirmation hearing, the Supreme Court handed down a unanimous decision. Even Clarence Thomas joined it. A completely unanimous decision reversing a decision that Gorsuch had handed down a while back, which would have nuked the rights of disabled children in public schools. All 8 of the justices read his interpretation of that law as no, this is just wrong, and the way you read it would render the law a virtual nullity. If you look at his forced arbitration case that we were just recently discussing, he, very smugly lectures Justice Ginsburg, who, by the way, has been doing this job a quarter century longer than he has, about how there's only one way to read federal law, and it's the way that he wants and not the way that she wants. And I'll tell you, I read the federal law, and it says what she says that it says. So he combines this very toxic mix of, tremendous confidence in his own judgment with poor judgment. And, that's not what you want in a judge.
To play devil's advocate here for a moment, because you're talking about how the Supreme Court overruled one of his decisions unanimously. So wouldn't that apply to other judges? I imagine the Supreme Court has overruled judges from before on decisions. Have a lot of his stuff been overruled, or was that just one case you could cite off the top of your head?
I mean, what you see with Gorsuch is you see a consistent pattern of very ideological opinions. You've seen him as a lower court judge writing what are called special concurrences, which are very unusual. A special concurrence is when a judge says, well, I have to follow this precedent, but I don't like it, so I'm going to complain about it for 15 pages and say that the law should be different. He would write those a lot, and he would talk about overruling foundational doctrines, doctrines that cut at the core of, what federal administrative agencies are allowed to do, or what the balance of powers between the judiciary and the executive branch, or the judiciary and the legislative branch. He would write these sweeping opinions calling for mass overrulings of very important precedents, and everything he said just happened to align with whatever ideas were in vogue at the Federalist Society's annual convention that year. So when you look at his record, judges get reversed. I worked on opinions when I was clerking for my judge that were reversed. It happens. But when you see this consistent pattern of someone who is consistently taking very ideological positions, consistently taking positions that are out of line with the views of his colleagues, who is calling for foundational precedents to be overruled, and is doing it, consistently from the far right, again, that's just a very worrying combination in a judge. I'm not going to dig a judge because once or twice in their career they're going to be reversed. It just happens. But when you see this pattern of behavior by the same person over and over again, you question whether they're in the right profession.
So recently in the Supreme Court, they ruled in Jesner versus Air Bank PLC that victims of overseas attacks can't use the Alien Tort Statute of 1789 to hold foreign corporations responsible for funding terrorism. The law seems pretty straightforward, yet this is probably the second time in 5 years they've changed the interpretation of that. Is there another way that victims from overseas can hold these companies accountable?
It depends specifically on what the company did. But yeah, there's this law called the Foreign Tort Statute that's been around, I believe, since the Washington administration, that in the past was used to allow American courts to litigate human rights violations that were committed in foreign companies. So, I know a lawyer who worked on a case when an American oil company basically pressed a bunch of people into slave labor and was forcing them to work on a pipeline. And it used to be that if you're going to press a bunch of people into slavery and, make them build an oil pipeline for you, you're probably not doing that in a country that has a very well-functioning independent judiciary. And so the idea was often that if you can bring them to American courts, then you could hold that company accountable. And the Supreme Court has not been interested in allowing this litigation for a while. There's been a series of cases. And so you might be able to go in through a narrow statute. Maybe that Congress passed something saying this particular action by this particular company or, actions like it are not allowed. But the sort of sweeping jurisdiction that was once allowed under the Foreign Tort Statute this Supreme Court has been very eager to kill it.
All right. We've talked about the Supreme Court becoming more and more ideological, so I want to follow up on that. So from 1801 to 1940, about less than 5% of the Supreme Court rulings were made by 5-4 votes. They used to be pretty unanimous or pretty overwhelming majority. After that, it started slowly increasing from over 5% until about the mid-'80s, where it jumped over 20% were bare minimum rulings. Why do you think that is?
I wouldn't overread the significance of 5-4 decisions. I mean, there have been a number of really bad 5-4 decisions. I mean, Lochner v. New York, which is considered one of the court's worst decisions in its history, which struck down an important labor law in New York, was a 5-4 decision. Hammer v. Dagenhart, which struck down the federal law banning child labor, was a 5-4 decision in 1918. So there have been plenty of bad 5-4 decisions throughout the court's history. I think that they've become more common for a few reasons. I mean, one is that there just used to be different, standards of etiquette within the judiciary regarding dissents. So, it used to be the case that a judge had to really, really feel strongly to write a dissent. If they just kind of disagreed, then they keep their disagreement silent. And now judges and justices who disagree with the majority opinion, they will say so more often. But that doesn't mean that there's more agreement. It just means that they're being more transparent when there is disagreement. You had, at the elite levels of the legal profession in the late 19th and the early 20th century, a consensus around some pretty abhorrent views. There was a view that the common law, which was the method of precedence, building on precedent, that has existed since the 11th century in English courts, was the sacred thing that represented all this collective wisdom, and legislatures were very dangerous because a legislature could change the law very quickly. And so for many years there was a hostility to the ordinary lawmaking process amongst the sort of elite members of the bar who tended to become appellate judges. That is no longer the case. So you used to have consensus around views that were wrong and that, weren't really contained in the Constitution, and now we don't. But then, a third factor is that the parties have sorted around different views of how judges should behave. And I think that's both unusual and very disturbing. There have been ideological disputes within the judiciary, on racial lines and economic lines. But this is the first time I can think of where you have such divergent views amongst two factions on the Supreme Court. One of those factions clearly aligns with the Republican Party, and the other faction clearly aligns with the Democratic Party. And that's not a position that I think the Supreme Court wants to be in if it wants to maintain its legitimacy. Because, again, the courts don't have a mandate from the people. The reason why people voluntarily follow their decisions is because they believe that those decisions come from some grounding in neutral principles of law and not strictly in partisanship. And if the court continues to go down this road where you can predict so many important cases based on which party has a majority on the bench, at some point I think that the court's legitimacy starts to strain, and that doesn't take you to happy place.
We have two big cases that are waiting for decisions from the court right now. We got the Janus versus AFSCME Council and the Masterpiece Cake Shop versus Colorado. So it's being touted that the ruling in Janus is negative. It's going to decimate public unions. Can you explain what that's about?
Sure. So, this is another example of where you see people have an ideological stake in the issue, and they're taking what should be a fight in the legislature and they're bringing it to the judiciary. So the issue here is that by law, if you're in a unionized workplace, if you're in a unionized shop, the union is required to bargain on behalf of everyone in your bargaining unit, regardless of whether or not they join the union. So if someone has the option to opt out and not join the union, not pay union dues, and they still get the higher wages and the better benefits and all the other stuff that the union negotiates for. So the problem with that system is that there's a danger that people say, wait, if I can get something for nothing, I'm just going to get something for nothing, and I'm not going to pay the union anything. So a lot of union contracts fix this problem by having a clause that prevents free riding. It says that non-members of the union have to reimburse the union for their fair share of the cost of collective bargaining and things like grievance arbitration. And this way, you don't have to join the union if you don't want to. If you don't join the union, you don't make any contributions to the union's political activity, but you do reimburse the union for bargaining on your behalf. And this way, the union can continue to thrive and function without the problem that people will decide that they want all the benefits without paying for it, and eventually the union doesn't have the money it needs to operate and collapses. What the Janus case seeks to do, and it looks like there's 5 votes for this outcome, is to say that you can't have these, they're called agency fee agreements, to prevent free riders within a public sector union. So your cops, your teachers, your firefighters, they all can get something for nothing until their union collapses, and then they just get nothing. And it's a very disturbing case. I think that the plaintiff's legal theories are very weak. And I think, the only reason this case is likely to do well is because there are more Republicans on the Supreme Court than there are Democrats, and Republicans don't like unions.
Masterpiece Cake Shop versus Colorado Civil Rights. It seems that that's been going through the system where Masterpiece has been losing their suits. So why do you think the Supreme Court is taking this up?
Part of the reason it's so shocking that the Supreme Court took this case is because the lower courts, they haven't been entirely unanimous, but they've been close to unanimous in saying that, no, you don't get to a religious exemption from civil rights laws. You can't discriminate against someone because you claim that your religion gives you license to do so. What this case is about is in Colorado, there's a law saying that you can't discriminate on the basis of sexual orientation. And you had a baker who didn't want to serve a couple because the couple is gay. And that's very routine discrimination case. This issue of whether or not religion trumps an anti-discrimination law has been around for a long time, and the court's been pretty consistent. They said in the 1960s that no Mr. Racist barbecue restaurant owner, you don't get to refuse to serve black people because you think that God also hates black people. At least the lower court said in the 1980s there was a school called Fremont Christian School that didn't want to offer health benefits to married women because their theory was that the husband should provide for the home, and that means that if you are a married woman, you shouldn't get health benefits because your husband should provide you with health benefits. And the court said, no, it doesn't matter if you have a religious belief that calls for that kind of discrimination against women. There's a law saying that you have to give the same benefits to your male and female employees. And so if you give health benefits to men, you got to give it to women too. So this is not a new issue, and the fact that there newly may be a majority to say that there is a religious exemption to anti-discrimination law, I think is very disturbing.
Would that be something that Congress could overrule if Democrats got the majority back, or is that just something that would be set in law?
They're probably going to go in through the Constitution on this, which means that realistically the only way to fix it is to just get a new majority on the court that thinks it's more important to protect people from discrimination than it is to protect the Christian right.
With religion, when the founders created the Constitution, right, they wanted to separate religion from political beliefs. But we see more and more common now, they have become merged. Do you think that's a dangerous precedent here?
Well, I don't think it's new that, people have individual values, including individual political values that are informed by their faith, and there's nothing wrong with that. Nor is there anything wrong with a legislator saying, I believe the death penalty is wrong for religious reasons, so I'm going to vote against the death penalty. Or I believe that it'd be wrong for us to go to war for religious reasons, so I'm going to oppose this war. There's nothing wrong with that. What's disturbing about Masterpiece Cake Shop is here you already have a law. The law deals with the areas where I think there's widespread consensus that it's necessary for the government to intervene. When you have discrimination on the basis of a trait that someone has no control over, and the response from a handful of people who want to engage in discrimination is that they shouldn't have to follow the law because they think that God is compelling them to discriminate. That's just not allowed. And, like I said, this has come up over and over again, that people have said, I should be allowed to violate a civil rights law because of my religious beliefs. And time again, the court said, no, of course you don't get to discriminate against someone for that reason.
And that's it. I appreciate your time, and thank you very much again.
All right, thank you.